vote in a primary was a mere refusal of party membership with which the state need have no concern, while for a state to deny a vote in a general election on the ground of race or color violated the Constitution. Consequently, there was found no ground for holding that the county clerk's refusal of a ballot because of racial ineligibility for party membership denied the petitioner any right under the 14th or 15th Amendments. Since Grovey v. Townsend and prior to the present suit, no case from Texas involving primary elections has been before this court. We did decide, however, United States v. Classic. We there held that Section 4 of Article 1 of the Constitution authorized Congress to regulate primary as well as general elections, where the primary is, by law, made an integral part of the election machinery. Consequently, in the Classic case, we upheld the applicability to frauds in a Louisiana primary of Sections 19 and 20 of the Criminal Code. Thereby, corrupt acts of election officers were subjected to congressional sanctions because that body had power to protect rights of federal suffrage secured by the Constitution in primary as in general elections. This decision depended, too, on the determination that under the Louisiana statutes, the primary was a part of the procedure for choice of federal officials. By this decision, the doubt as to whether or not such primaries were a part of elections subject to federal control, which had remained unanswered since Newberry v. United States, was erased. The Nixon cases were decided under the Equal Protection Clause of the 14th Amendment without a determination of the status of the primary as a part of the electoral process. The exclusion of Negroes from the primaries by action of the state was held invalid under that amendment. The fusing by the Classic case of the primary and general elections into a single instrumentality for choice of officers has a definite bearing on the permissibility under the Constitution of excluding Negroes from primaries. This is not to say that the Classic case cuts directly into the rationale of Grovey v. Townsend. This latter case was not mentioned in the opinion. Classic bears upon Grovey v. Townsend not because exclusion of Negroes from primaries is any more or less state action by reason of the unitary character of the electoral process, but because the recognition of the place of the primary in the electoral scheme makes clear that state delegation to a party of the power to fix the qualifications of primary elections is delegation of a state function that may make the party's action the action of the state. When Grovey v. Townsend was written, the court looked upon the denial of a vote in a primary as a mere refusal by a party of party membership. As the Louisiana statutes for holding primaries are similar to those of Texas, our ruling in Classic as to the unitary character of the electoral process calls for a re-examination as to whether or not the exclusion of Negroes from a Texas party primary was state action. The statutes of Texas relating to primaries and the resolution of the Democratic Party of Texas extending the privileges of membership to white citizens only are the same in substance and effect today as they were when Grovey v. Townsend was decided by a unanimous court. The question as to whether the exclusionary action of the party was the action of the state persists as the determinative factor. In again entering upon consideration of the inference to be drawn as to state action from a substantially similar factual situation, it should be noted that Grovey v. Townsend upheld exclusion of Negroes from primaries through the denial of party membership by a party convention. A few years before, this court refused approval of exclusion by the state executive committee of the party. A different result was reached on the theory that the committee action was state authorized and the convention action was unfettered by statutory control. Such a variation in the result from so slight a change in form influences us to consider anew the legal validity of the distinction which has resulted in barring Negroes from participating in the nominations of candidates of the Democratic Party in Texas. Other precedents of this court forbid the abridgment of the right to vote. It may now be taken as a postulate that the right to vote in such a primary for the nomination of candidates without discrimination by the state, like the right to vote in a general election, is a right secured by the Constitution. By the terms of the 15th Amendment, that right may not be abridged by any state on account of race. Under our Constitution, the great privilege of the ballot may not be denied a man by the state because of his color. We are thus brought to an examination of the qualifications for Democratic primary electors in Texas to determine whether state action or private action has excluded Negroes from participation. Despite Texas's decision that the exclusion is produced by private or party action, federal courts must for themselves appraise the facts leading to that conclusion. It is only by the performance of this obligation that a final and uniform interpretation can be given to the Constitution, the supreme law of the land. Texas requires electors in a primary to pay a poll tax. Every person who does so pay, and who has the qualifications of age and residence, is an acceptable voter for the primary, as appears above in the summary of the statutory provisions set out in Note 6. Texas requires by the law the election of the county officers of a party. These compose the County Executive Committee. The county chairmen so selected are members of the District Executive Committee and choose the chairman for the district. Precinct primary election officers are named by the County Executive Committee. Statutes provide for the election by the voters of precinct delegates to the county convention of a party and the selection of delegates to the district and state conventions by the county convention. The state convention selects the state executive committee. No convention may place in platform or resolution any demand for specific legislation without endorsement of such legislation by the voters in a primary. Texas thus directs the selection of all party officers. Primary elections are conducted by the party under state statutory authority. The County Executive Committee selects precinct election officials, and the county, district, or state executive committees, respectively, canvass the returns. These party committees, or the state convention, certify the party's candidates to the appropriate officers for inclusion on the official ballot for the general election. No name which has not been so certified may appear upon the ballot for the general election as a candidate of a political party. No other name may be printed on the ballot which has not been placed in nomination by qualified voters who must take oath that they did not participate in a primary for the selection of a candidate for the office for which the nomination is made. The state courts are given exclusive original jurisdiction of contested elections and of mandamus proceedings to compel party officers to perform their statutory duties. We think that the statutory system for the selection of party nominees for inclusion on the general election ballot makes the party which is required to follow these legislative directions an agency of the state insofar as it determines the participants in a primary election. The party takes its character as a state agency from the duties imposed upon it by state statutes. The duties do not become matters of private law because they are performed by a political party. The plan of the Texas primary follows substantially that of Louisiana, with the exception that in Louisiana, the state pays the cost of the primary, while Texas assesses the cost against candidates. In numerous instances, the Texas statutes fix or limit the fee to be charged. Whether paid directly by the state or through state requirements, it is state action which compels. When primaries become a part of the machinery for choosing officials, state and national as they have here, the same tests to determine the character of discrimination or abridgment should be applied to the primary as are applied to the general election. If the state requires a certain electoral procedure, prescribes a general election ballot made up of party nominees so chosen, and limits the choice of the electorate in general elections for state offices, practically speaking, to those whose names appear on such a ballot, it endorses, adopts, and enforces the discrimination against Negroes practiced by a party entrusted by Texas law with the determination of the qualifications of participants in the primary. This is state action within the meaning of the 15th Amendment. The United States is a constitutional democracy. Its organic law grants to all citizens a right to participate in the choice of elected officials without restriction by any state because of race. This grant to the people of the opportunity for choice is not to be nullified by a state through casting its electoral process in a form which permits a private organization to practice racial discrimination in the election. Constitutional rights would